Hello, everybody, and thank you so very much for joining me today. I really appreciate that you're taking the time out of a very busy day, especially as we're hurtling towards the end of the year. We're all really, really busy, so I'm most grateful to you. Guess what? Women in Sectional Title now has 9 new sponsors. If you go onto our sponsor page at www.womeninsectionaltitle.co.za, you'll see that most of them are managing agents. We have one consultancy and also a maintenance company that's joined us just to make this platform more sustainable. Of course, we do give our huge thanks to our main sponsor, We Connect You, Johan van der Merwe, all the Van der Merwes. So that's Dani, Skalk, Toby, and of course Maritza Botha, for always being a staunch supporter of our platform. We look forward to watching you fly. Your progress has been phenomenal, and we are your largest flag flyer. So thank you so much for that too. Also, I think a reminder is in order to have a look at what NAMA is offering you as managing agents and portfolio managers, if you are listening out there, to say that there are workshops that are taking place all over the country. And not only workshops, but in Gauteng North, we also have a lawn bowls tournament, which will be really superb. I think that's going to be great. It's going to be in Gauteng North in Pretoria at the Wingate shop, a Wingate golf course. So I think that'll certainly be amazing. I'll try and speak a little bit louder. I see somebody saying that sound is a little bit odd. So let me get closer to the microphone. I hope that's okay for you. Okay, so today we need to be speaking about the challenges in sectional title. And one of the biggest challenges that we have in sectional title at the moment is not about maintenance or meetings or even money. The biggest challenge we've got is around communication. Communication, too many owners are really left infuriated by the fact that information is withheld from them using the Protection of Personal Information Act as a shield, for example, to getting the information. And I think that really erodes things like trust and transparency. So it's a good idea that we really clarify and understand what communication needs to be like in sectional title issues. Today, we're going to talk through 3 things. The one is, what are the stumbling blocks to communication in sectional title in these complexes? What are the problems and why does it appear to come to the fore all the time? Secondly, we're going to talk about prioritizing clear and consistent communication. And thirdly, we're going to look at the legal side of it, and we're going to look at POPI, and we're going to discover also what the consolidated practice directives say practically. I'm all about practical. We're not going to go on and on about the law and sections in this particular clip. We need to get our facts together and clearly so that you understand exactly what's going on by the end of the webinar. Okay, so what are the stumbling blocks to communication? I think the main thing is we're too busy. I think that we are time poor. And certainly business has been moving along at breakneck speed over the last 10 to 20 years. And the sooner we acknowledge that, the better. Because people do tend to get tired and you tend to expect the same things as we expected from ourselves over the last, if we've been in business for 10, 20 years. And it's not the same. Business has completely changed. And I think the forces that have conspired to come together for us to be in this position is firstly computing. The second thing is connectivity. And then you've got collaboration. And I'll just go through those things briefly for you. So computing, gone are the days where in the 1930s you had huge warehouses that held computers, huge computers and servers. Now you've got your slick, sophisticated little computer on your desk or your iPad, and you've got software to go with that, which is just adding phenomenal value to whatever industry you're in. Then there's connectivity, which has increased apparently 1,000 times since the 90s. So in the 90s, 1 gig would take a day and a half to download, whereas now it's taking a few seconds. And you only have to use ChatGPT to know that you ask any question and it comes up almost immediately. Collaboration, we've got Facebook. So you've got to worry about who's putting information about your reputation on Facebook. You've got WhatsApp. You've got to worry about who's, which client is requesting immediate attention and instant gratification. You've got LinkedIn, which is distracting you with all these job opportunities and availability of everything. So we're distracted, we're busy, we're tired, and that's why emails often get ignored. And that's why a managing agent would rather perhaps fob somebody off saying, look, we can't give you what you're asking for because of statute or because of the law. So let's just talk a little bit about improving communication in 2025 and what it means. And this is from my personal experience in this industry for a long time. The couple of things that are problematic and we need a phenomenally big or really powerful mindset change, is when it comes to things like nervousness during communication, rambling, very bad thing, and also boredom in our industry. And I'm going to unpack that quickly for you. So when you're nervous and you're a portfolio manager and you're thinking about your meeting or about your email that you've got to write, or the fact that you haven't properly prepared for an AGM maybe, that nervousness is all about being self-conscious. And as soon as it's all about me, and myself, that nervousness is just going to build. So one of the things that as a practical tool in this toolkit that we're going to provide you is to say, we've got to shift from self-consciousness to serving the community around us. So that's got to be a shift towards the actual people that you're dealing with. If you're talking to trustees, place your attention on the trustees just to say, how can you make life better? How can you make life more beautiful for this trustee that's in front of you, however aggravating they might be? How do you improve one sectional title complex at a time? So the moment that you take and reframe that and shift towards service, a mindset of service, that's going to definitely sort out nerves. And it's something that's definitely helped me in my life to do. I also teach Pilates. And when you are sort of hanging in a front forward position, I'll often say move from your heels to the balls of your feet. So shift. And that little shift just engages something. It engages the hamstrings. And in the same way, this little shift is going to psychologically change you. It's going to move you. Then the bane of my life, rambling. Rambling in any communication is a trait which is, it just creates ineffective communication. And I hate it when people talk in circles. I dislike it when people in meetings certainly have to say the same thing as somebody else has said 100 times. And that's why you're sitting as portfolio managers or even as trustees in meetings for way too long. If it were up to me, I think I would make meetings where you actually have to hold a plank position. And I think that would focus the mind. But what can focus the mind even better than that probably is if when you're speaking and communicating, you say the one thing that I want to talk about today. Or you'll say the 4 things that we're going to address which are problematic are 1, 2, 3, 4. Because then your monkey mind stops jumping around and you're focusing on the core message that you want to be giving as that portfolio manager or as a trustee to the owners in an AGM. Then boredom is a very big problem, because if you feel that your industry is boring and dry, and you feel that your work is boring and dry, and the people that you're dealing with as trustees are boring and dry, then you've got a problem, because they might be boring and dry, but you are not. And you are the protagonist in the play, in this communication scenario. So the fact is that if you are curious and if you try to convey things in a really happy, fun, excited kind of manner, and you've got information that you can help people with, I think that goes a very, very long way. I mean, I had a lecturer, just to let you know from a personal point of view. His name is Arnold Shapiro, and he still practices. And he was lecturing on estates. Now, estates is dry and boring, trust me. But you know, that man made things come alive to such an extent that a lot of people went into that area of the law actually because of him. So I think that is something to really look at. And work is noble, work is so noble. So it's a way to just make it creative and beautiful and to uplift the lives of everybody around us, all these sectional title owners. What can you do for them today? Start of the week on a Monday and say, right, in each building, who am I going to target to make their lives better today, or make the storytelling better, and to connect with that human tapestry of all these people that you've got access to in your buildings. So for me, that is key. The last thing is immersion. So immerse yourself in things 100%. When your toes one side out and one side in, you're not going to get that purpose, and you're not going to build the communication skills that you want. Also, while we all concentrate on our visual image, what we wear and how we look, you've also got to look at your vocal image. And that's something we can all improve on. You know, if you're very quiet, or you're not, accessing your voice, and you're not, sounding confident enough, there's so many courses that you can go on to look at confidence building, because that really gains attention when you're in one of your meetings. So that's talking about now navigating clear, concise communication skills and prioritizing that over anything else, because that's going to keep your clients, and you're going to be able to really, really act with purpose. In my experience, the other things that create drama with communication is that financial communication is not enough. So when we're communicating, it's a sensitive topic, sensitive touch point at the moment, financial stuff. So break down expenses if you're a managing agent talking to trustees, or if you're trustees explaining a project to owners. Bring in documentation that is supporting documentation. And obviously have your quarterly meetings, or even more meetings, to be able to, not too many, I'm not a big fan of so many meetings, but at least quarterly, to be able to convey information. If you are handing over arrear levy collections to attorneys, make sure that the trustees and the managing agent, you have meetings with those attorneys, so that it's like a tripartite relationship of communication with the lawyer, with the trustees, and with the managing agent in the same meetings. Because otherwise, it just, I've had that first-hand experience where everybody's undermining everybody else. So keep that in mind. Then what about maintenance? Maintenance also, touch point on communication, because that involves money. And also people can see that things are deteriorating, so you're under pressure as a trustee or as a portfolio manager. So a couple of areas overseas, particularly in New South Wales, what I've noticed a couple of their managing agents doing is coming into this century by utilizing videos and pictures more. So they'll take pictures of a situation that requires maintenance, maybe the buildings that require maintenance, and then they'll upload the pictures over time, so that when it comes to looking into the money side for the maintenance project, you've got sort of evidence that you've got a maintenance problem on your hands. Also, in a scheme, just like you use newsletters, it's great to use videos and pictures to tell the owners what is being done in their scheme. Hey guys, look, we've just fixed all the gutters, and the great news is that we're looking at our painting coming into effect maybe early next year, or whatever it is. That is what communication is all about. And it's all very well to have a maintenance, repair and replacement plan. Very good, you have to do that. But I think we all need to get more creative about how we're working in these schemes, make things a little bit more fun. Obviously, the best form of communication at the moment in our schemes is to have a great portal. And that's where a crowd like We Connect You comes into play. I mean, a portal which is a document repository where you can access information, you can access your newsletters, you can quickly access your accounts and things that you need as owners, and then in another tier, possibly the trustees. Crucial. If you don't have a great system there, then I would say that is really, really a major, major problem. Okay, so the point that we are making here is that we need to blend speed and convenience with warmth and transparency. So the other things are, for example, to inject a bit of personality into wherever you're going, whatever you're doing, I think, is to also go on site. You've got to go on site. We've got to look at what personal communication, and while we're going to use AI, and we're all for that, absolutely, 100%, we need to also look at what personal information and personal stories that you're going to get from everybody. Okay, so let's just go. I just want to see. Thanks, Glenn, Darcy, and Susan. Change from self-consciousness to a service mentality. And Glenda says, I love this for myself. Thank you for awakening the brain to this. Okay. Now, I think what I'd like to do is to go on to the POPI story, because I know that you're all very interested in that. And that's what we are going to look at doing. Okay, let's just go back. I'll take you back to here. Right, so the first thing that we need to say, and the first thing I want to tell you, is that the Protection of Personal Information Act is not a legal justification to withhold your routine governance documentation. And this slide is short. It's only 4 slides, but I think I'd like to put it in perspective so that we're not, again, rambling on about the acts, etc. But the one thing that you do need to know, the source for what we're saying, and for POPI and for PIA and for all of this, if this is the first slide you get in your head when I talk to you about POPI, then my job would have been done. So the Constitution of the Republic of South Africa is at the core of everything around us. And that came into play on the 4th of February, 1997. So on the one side of the scales, you've got section 14 of the Constitution, and it says everyone has the right to privacy, the right not to have, firstly, their person or home searched, their property searched, their possessions seized, the privacy of their communication infringed. And that's the one that we focused on, is D, the privacy of their communication infringed. And that all culminated in the Protection of Personal Information Act from the Constitution. On the other side of the scales, you've got section 32 of the Constitution, and that says that everyone has the right to access information that is held by another that is required for the exercise or protection of any right. And that culminates in the Promotion of Access to Information Act. So whilst we all have the right to our privacy, people have the right to ask us questions about certain things, particularly if it's in the protection of or exercise of any rights. Okay, so that's pretty clear. Now, let's go on to owners. Okay, so owners, where it's relevant in terms of POPI, only relevant information, which is obviously linked to the management of the scheme, that is what may be processed. And remember, in our sectional title schemes, we also need information officers. And we know after a lot of toing and froing that your information officer can be the managing agent or can be the trustee. So any information which is like personal health information, salary or tax information, social habits, hobbies or memberships, personal details about divorce or custody or about any other kind of relationships is not something that is processed, doesn't have to be processed. But what needs to be processed is information, and we'll talk about what's in the Act in terms of what you have to have. But I do think it's important, and this is stipulated in the directives, the CSOS directives, these 3 things. The first one is deemed consent. Owners are deemed to have given consent for trustees and managing agents to have their details. So no owner can say, well, you as a trustee did not have my consent to give my details to the managing agency. And some people do try and do that. So that's something. Also, I think if you're a trustee, what it does mention is that you need to understand that you are sort of open by virtue of your position that you hold, and that your personal information will probably be out there. Also, owners in arrears or in breach. So trustees do not require their consent to forward relevant personal details to attorneys. And that is something that came up in my practice actually now, where we've got a guy who's very upset that he's in arrears, obviously, and that we as attorneys have taken action against him. It was just one letter of demand. You can't believe the hoo-ha about this letter of demand. But he reported us to the Law Society, and he's brought a case at CSOS to say that the managing agent didn't have the right to give us as attorneys his personal details, and he needed a whole lot of consent signed, and obviously that's not right. As soon as you're in arrears or in breach, or the third one, as soon as you're involved in dispute proceedings, and this is very important, there's no requirement to follow POPI or PIA, because that information then has to become available, obviously though, in relation to that dispute. Nothing else matters except what is needed. So we've all got to be very careful about that. Now, I wanted to just take a moment with owners in arrears. I need to digress, and I know we've got a lot to talk about, but this has come across my desk now in August. It's a case. We'll make it available to you, and it's a case about arrear levies, but it's important because as managing agents, what I need you guys to do right now with your trustees is go and get a trustees resolution signed. And the trustees resolution comes about, it's a case called Silawas Body Corporate, it's Cilaos Body Corporate, and Sarah Singiwe. And it came out for us to see in August, the middle of August 2025. It came out for us to have a look at. And basically what happened here, what happens when matters go to attorneys for arrear levies is that we are not allowed to actually, or managing agents are not allowed to place our legal fees, our full legal fees, onto the account of the debtor, because at the end of the day, you either have to have a bill tax, this is in the management rules, or you have to have agreement about the costs. And obviously, you're never going to get agreement. So we've got to go run off and get bills taxed. In this case, the trustees had put together a resolution which said that they were entitled to charge the owner, if they're handed over, will be liable to pay the costs of the attorney's fees on a scale as between attorney and client, as charged by the attorneys, as per the invoice received from the attorneys. Now, we've been aware of this kind of resolution, but this case actually sets it out. It was in the Gauteng High Court, and the judge said that because there was this resolution, then they could place attorney-client fees onto the owner's account. You didn't have to wait for taxed bills of cost. So please put this in. Also, if you can tell people, you can change the rules as well to add that in. And if you don't mind, if you can also add in your rules about being able to obtain disconnection applications in your rules. And so the trustees have resolved that they can apply to court to obtain a disconnection application. That would also help us in our disconnection applications as attorneys. All right, so I have digressed. I really apologize, but I do think that that's incredibly important to understand, and it's hot off the press, which I like. Okay, then we've got sectional title legislation. But what does this say? We need to understand it. Practice Management Rule 27.2 requires the trustees to obtain the details in relation to owners, trustees, and tenants. So we know that they've got to get the full name, the ID, passport number, if applicable, the address, the email address, and telephone number. So it's also of tenants. So I've underlined that, of tenants. Section 3(1)(n) of the Sectional Title Schemes Management goes to further to say, upon reasonable request, the trustees must furnish trustees and owners names and addresses. That's what we use a lot in terms of when people ask for information. We see if it's reasonable and if it pertains to the operational governance and running of the sectional title scheme. And that will usually give you your answer as to whether or not you can withhold it, or you can say, no, we need somebody's consent to share that. Then you've also got Management Rule 27.4, which says an owner, a registered bondholder, or a person authorized by a member is entitled to receive documents and records of the body corporate. And in order to get documents of a body corporate, they give 10 days I'm not sure how you guys feel about that as managing agents. Is that too little? Is it too quick for you? And of course, records of the body corporate, that would be within 5 days. So that is actually a lot better. So I think that the main thing here is before you decide whether or not to withhold the information to somebody, you've got to look at the practice directives, and that is what we are going to have a look at here as well. So in terms of Chapter 5 of the practice directives, if a member requires all these things, they actually have to fill out prescribed Form 2. We're going to go through these things one at a time. But prescribed Form 2 talks to the Information Regulator and the POPI, the Promotion of Access to Information Act. And that is the form is actually on the regulator's website. So what they're saying again, you know, I used to give information to my clients if they said, we want something, we want some documentation. I used to say, well, you can't ask the managing agent to actually email you copies of everything. Rather go to their offices, ask them in writing, and then go to their offices and inspect documents. But now with the CSOS directive, you need to fill out prescribed Form 2 if you want. Minutes of meetings, AGM, and trustees meetings. By the way, I have found a lot of times now with my clients, trustees just aren't getting minutes of meetings in. They're meeting in a very informal way. And I think we've got to go back as managing agents to just press that you actually do have to have meetings, minutes of meetings for trustees. You've got all these little AI recordings and things that they can make life a lot easier. Then also the rules, management and conduct rules and compliance certificate. Also have to fill out this form. Audited financial statements, bank accounts for administrative and reserve fund. And the CSOS, the directive makes it very, very clear that you actually must do both. Procurement decisions, election outcomes and processes, investments for scheme, information relating to security and maintenance. So if you're worried that you're upset that, like in the Cape Town building, I've got my one owner is exceptionally worried about the fact that the trustees are maintaining their properties, but they're not, doing anything for the rest. And I've actually just written a letter to say to the trustees that we need to see details of all payments and finances relating to maintenance issues. This is the form that I would have needed to fill in. Body corporate insurance policies, obviously that as well. So any of you would like that form, I've got it available. I'll just go through it quickly just to let you know. It's a couple of pages. So it needs whoever's asking for it, we need the personal information, and it's directed at the information officer. So you've got to find out who the information officer is. Particulars of the record are requested. So whatever you want access to, you have to put the description, if there's a reference number, the type of record, if it's just virtual images or if it's recorded words or information, if it's on computer or if it's machine readable. The form of access is also, you have to put an X if it's on a flash drive or if it's on a cloud storage server or if it's just printed. The manner of access, so how do you want it to be accessed? Do you want, it says fax of information. I don't think anybody uses faxes, but it also says postal services, courier service, email, or cloud share. And then particulars of the right to be exercised or protected, and the fees. So you have to pay a fee. I think the fee when I last looked was 140 Rand. You need to pay that fee. So let's get with it so that we understand what is necessary, what we need to be doing there. Okay, so now that we've gone through that, I think I'm going to stop sharing the screen. And I'm just going to go through a couple of scenarios because I think, what does Susan say here? Okay, let's just see. Yeah, sorry, I just want to go through some questions because they're important. Please put the case details in the chat. Yay for the resolution. Please also provide the wording of the resolution regarding attorney's fees. What counts as reasonable request for owners and or residents' contact details. How do owners obtain contact details when they want to organize a special general meeting to dismiss the trustees? Yeah, that's the biggest one, isn't it? If a non-trustee requests email addresses for governance purposes, are we obliged to supply this? Welcome back, Marina. Thank you, Kath, and thank you for hosting. Yes, please, if you would kindly forward me the form. My secretary Lola will take that information. But basically what I'm going to do is I'm going to send everybody who's on this website, I'm going to send them Form 2, I'm going to send them the Practice Directive, Chapter 5, and I'll send them a copy of the case. Is that okay? I think that will cover all of you. So what counts as a reasonable request? Well, let's go through a couple of scenarios. I think that's important that we do that. So what happens if, for example, let's take a few scenarios. An owner says, right, I'm not happy with the cash flow of this building. It looks like we, ignoring maintenance and that kind of thing. So I want to see the levy schedules for the building. I want to see what cash flow is all about, and I want to see the arrears. So in that situation, the owner is entitled to that information, but for example, the levies, the names on that statement should be redacted, and you can give them sort of a clean version without actually sharing personal information about that. That is something you can do, or else you could ask that person to come in and inspect the books of account and record, but they would have to sign some sort of disclaimer, like an NDA, to say that they would not then disseminate that information to anybody else. Okay, so that's something that you could look at. Something else, let's go through. I've got a couple of scenarios that I've thought about. So what about an attorney on behalf of an owner requests a copy of all levy statements to check if levies are applied fairly? In other words, if you are suing only their client, or if you should be suing everybody else who is in arrears. And there I would say that you wouldn't be able to give out that information to that attorney. I think that's personal information, and that attorney is only entitled to have the information relating to his or her client. So we don't want to breach personal information there. Then what about that owner who wants the information to start a WhatsApp group because they say that there's not enough communication and they need all the owners' telephone numbers so they can start a WhatsApp group? So when somebody says that they want to start a WhatsApp group, then it immediately alerts me to the fact that it's like going to be a coup d'etat, and there are people who are going to be wanting to take over things and push their own agendas forward. So unless, of course, always remember, unless there is consent, if there's consent, all fine, no problem. But then every owner who's on that WhatsApp group must consent. Otherwise, that would be a breach of personal information. I find giving out cell phone numbers is probably the worst breach. ID numbers, it's public actually. Anybody can go and find anybody's ID number nowadays. But when email addresses and cell phone numbers, and especially cell phone numbers, that's a little bit too close to the bone. So I wouldn't like you to suggest that you spread those out. There's one here which might be a little bit contentious. What if an owner asks for another owner's number to phone them and complain about their barking dogs? So I think is it a reasonable request to release that information? Well, I think first of all, we've got to look at what other remedies could this person have gone through. And they could actually take themselves to the house of that person with a barking dog, or to the tenant, and ask for that information themselves. And I think that would have to be what they do first, rather than get the number. On the other hand, I suppose you could say, well, it is for compliance purposes, in terms of the rules, and it is within the scheme, and it is for the greater good. Just as Susan asked, what happens if owners want to actually organize a meeting to dismiss the trustees, and there's trustees you've been asked to give everybody's information? I think you have to give the information. It's in the course and scope of the governance of the scheme, and if people are unhappy, they should be allowed to call a meeting using their 25% PQ to call that meeting in terms of the Sectional Title Schemes Management Act, and I don't think you can stop that. But certainly, what you can stop is a trustee's friend who happens to be a debt collector, for example, from going and asking for the details of all the owners because he wants to advertise that he's good at debt collection and that he thinks he can help the scheme. It's fantastic. That goes for landscapers as well. I've had a lot of cases where landscapers want the database of these schemes so that they can advertise. So advertising is not on to a scheme, obviously. You're not allowed to do that. An owner who wants trustees' minutes, we've said that trustees' minutes, an owner can have that, but they must complete that form too. Unless you just want to say to them, yeah, we know that you can have it. I mean, I think it starts creating disharmony if you say, well, go back and do the form too. It's almost like, again, you're fobbing people off. And this is what we want to get away from. We need to get away from that. We need to get into that service mentality that we spoke about earlier. An owner who wants an insurance letter because of their flat was flooded, and they'd like to see the settlement letter from the insurance company regarding their flat. Yes, I think you are allowed to give that. We had a fun example, the ones where we were asked, one of the owners asked the trustees for the number of a very good-looking owner who'd moved in, but that obviously was not for the right purposes. That was more for social liaison, and obviously you're not allowed to give that number unless the good-looking guy actually said yes. Then what about, I was thinking actually this morning as I was getting ready, what about the situation where you've got an owner driving outside the complex and he bashes into somebody, and then that somebody follows him to the complex, and he quickly goes in through the gate. That owner realizes he lives there and then asks the trustees for his information so that, that he can be sued because he caused damage to the car and he didn't want to talk to it. It was like a hit and run kind of thing. In that case, again, it's got nothing to do with the governance, the finances, anything about the scheme, so that wouldn't be allowed. A similar situation, if somebody is dealing with, let's say there's a service contractor on the premises, maybe painting, or you can call it a builder, and that builder also damages something that's owned by an owner, or the owner damages something owned by the builder, like hits his car, or I don't know, pushes his ladder over or something. Can that builder then go to the trustees and say, I want personal information of that person so that I can take legal action against them? Even if it's in the course and scope of his work, I don't believe that that builder would have access to that personal information. So there are a number of scenarios that play themselves out, and I think, yeah, what is reasonable for one person is certainly not reasonable for another. But I do know that a lot of you have got questions, and let's have a look at somebody else. There's a question from Simone. May a body corporate member who has a 50% share PQ in a block of apartments at an AGM vote that they do not want a certain trustee to be part of the trustees for the following year? Well, yes, of course. I mean, that member can certainly ask for that, but you would need the support of one or two others because you need 51% in order to get rid of a trustee in any event. So you wouldn't be able to with 50%. You'd need a little bit more than that. Clive says Form 2 will serve to frustrate many for basic requests such as rules and unsure of the purpose for form for basic sensitive information. Yeah, I agree. As soon as I see I've got a form to fill in, again, it's making life harder, just making life harder. And it's a particular frustration, even for me at the moment. I have to confess to you guys, as an attorney, it's becoming a bit of an uphill battle to practice because of all this fee cake. I mean, you have no idea what we've got to complete in the way of forms. As a client, if a client comes to us, I mean, we've got to, are you politically affiliated? Give us an organogram of your company, and if they're subsidiaries, we need organograms of those subsidiaries. because obviously because of the grey listing of South Africa, as attorneys, we've been targeted. And in my view, we've got to be making life easier for our clients, not harder. I don't know if any of you follow Nikki Bush. She's a speaker, really, really good speaker. I follow her very closely. And on her Facebook page the other day, she was talking about going to airports. And she went to the airport, at the King Shaka airport the other day. And she said, you know, those trolleys. I don't know about you, but I mean, I nearly get my back right out of position trying to get those trolleys out. And at the King Shaka, they put the trolleys in such a way that you can just easily take them out. And this is what it's all about. This is what business for me at the moment is all about, making things easier. So yeah, Clive, I mean, I couldn't agree with you more. It's harder, but this is what is in the CSOS directives. If I was a managing agent, I would give over that information, because you can give that information over, and I really wouldn't frustrate and completely aggravate anybody about it. Kat says, Susan, the managing agent will not give me the owner's details despite me being a trustee. Could write a book about non-compliance. Yeah, no, 100%. Mel says, a colleague of mine is currently dealing with a matter where an owner was handed over to attorneys for collection. The trustees approved the handover. The invoices received from the attorney were settled by the managing agent. However, the trustees are now requesting that the managing agent refund the legal fees that were paid on behalf of the body corporate, as they did not approve the individual invoices. Are the trustees correct in wanting the funds refunded, or was the managing agent correct in settling the invoices based on the approval of the handover? That's a great question that comes up in my life certainly all the time, because we run quite big a really big collection department here at my firm. Again, it's that tripartite relationship that I cannot understand why sometimes managing agents do not work with the attorneys and the trustees at the same time, so everybody knows what's going on. It depends on the contract, Mel. So if your contract, your managing agency contract, says that the mandate is given by the trustees to allow the managing agent to hand over arrear levy collections as like an agent, then I would say that the attorney then has to tie up that relationship and make trustees sign their mandate form, which shows what their fees are, and that would have sorted that problem out. If the managing agents are loose cannon and it's just, going off on their own mission and not advising trustees about what the costs are, what the tariffs of the attorneys are, yeah, I think there is a problem. So either it's tied up in the contract, or you may have a problem because you need a mandate signed by the trustees, not the managing agent, actually, unless it's in the contract. So yeah, let's be careful of that one. Serena's in a very humorous mood today. Okay, is the principle not sharing information with owners as opposed to people and business outside the body corporate? May annual financial statements be shared with prospective buyers? Well, the only way that can happen, Susan, is by asking you. It wouldn't be between the buyer wouldn't be able to ask for it, but certainly the owner, the seller, would be able to ask for it. And then the seller can obviously definitely share that with prospective buyers, but it's just that who asks for it is the issue. Okay, if a non-trustee requests email addresses for governance purposes, are we obliged to supply this? Yes, if it's an owner, definitely. Governance purposes, definitely. Not only trustees, everybody is this information is open and available to everybody. Remember, you can go how many years back? 6 years back with information. If it's more than that, then you could say no, sorry. Yeah, so there I've answered that. Serena says, sorry, I was laughing about the good-looking guy you mentioned, not about the buff. Okay. Yeah, no, we've seen it all, Serena. There's nothing we haven't seen. And then again, I think that, and then today I'll see something. I just shake my head. But again, it's all about seeing the funny side of things and being human, really. It's about human connection. If you're not a people's person, probably not so good to be in this game. But I must say, I love where I am. I love sectional title. I enjoy it. And I enjoy also educating, and I enjoy talking to you guys. And I love feedback, and I'd love more feedback, because I honestly believe in the last minute that we've got to tell you that this platform is going to go from strength to strength as we get more managing agents on board. Remember, if you want to be the 10th managing agent or service provider who would like to get onto our sponsorship list, please contact me on marina@bbmlaw.co.za. I think we've got something good going here, and I look forward very, very much to our next webinar in October. So thank you so much. Take care. Look after yourselves. Until next time.